My name is Tatjana Hörnle, and I'm the Director of Criminal Law at the Institute for the Study of Crime, Security and Law in Freiburg. I'm just coming from a keynote lecture I gave here at the Max Planck Law Conference, and the subject was the emergence of sexual autonomy as a fundamental right. I looked at the notion of sexual autonomy and specifically how the notion of consent, which is central for modern law, should be conceptualized and what exactly consent should mean. It's quite complicated to understand what consent means and how you should define it, and to understand that there are some choices that need to be made between different models. For example, no means no or only yes means yes. Sexual offense law had always been a field for struggles in terms of gender relations, but also of struggles between religion, moral and criminal law, the way criminal law should or should not be independent of extra-legal moral forces. Power is relevant on a general level for everything we do in criminal law theory. It's always about balancing interests between citizens, and balancing is the more polite formulation, but actually what's behind it is which groups in societies have, in the end, the power to defend their interests with the means of the criminal law. But the classical feminist argument of seeing oneself in a position of powerlessness, I don't think that's accurate anymore. If you look at modern legislative work, particularly in the area of sexual offense law, you will see that feminist thinking has influenced the way law is today.